everyone, Solmas Tagavi with Tagavi Immigration Law, and welcome to our live both on Facebook and TikTok, where we're going to talk to you about the current status of Biden's new law. So Biden's new law, keeping families together, parole in place, we're going to call it Biden's Parole. It is a law that came out it was announced in June of this year. It became in full effect this August. And I'm going to tell you about what the eligibility requirements are for Biden's parole in place, what is the history of the litigation, and where we stand now. This is a amazing live and perfect timing because we have some really good updates to give you guys and to continue to educate you guys about what's going on with Biden's new law, Biden's parole in place, keeping families together. All right. So first I want to talk about the general eligibility requirements. So this is a benefit for people who are married to U.S. citizens. So people who are married to U.S. citizens, they have entered the United States undocumented, meaning without authority from the government, without a visa or work visa or anything like that to enter. So entered without documentation, married to a U.S. citizen before the date that this law was announced, which was June 17th, 2024. And that they can prove that they have 10 years physical presence in the United States. Again, this is from the date in which this law was announced, which was June 2024. So if you have 10 years going back to 2014, then that is 10 years of physical presence in the United States. That you have no disqualifying criminal record or criminal history, and those are the basics of Biden's parole in place. We've gotten a lot of questions for people that do have a criminal history, people that have been ordered removed, so they have an order of deportation, or people who have multiple entries, so more than one entry without authorization. So if you have these three things, you definitely want to book a consultation with us and talk about your specific case so we can weigh what are the benefits, what are the negatives or the risks involved. But all of this needs to be done as soon as possible, okay? And I'm going to tell you why. So starting in August 26th, so a few days after Biden administration rolled out the forms, the process, the electronic filing, and all the things that we could go and use and apply, they were then sued by the district court in Texas, and that triggered a stay. So what that means is the judge said, while we are determining a decision in this case, we are going to stay this application process. So what does that mean? What does a stay mean? That means that you can still apply for Biden's parole in place, okay? Their USCIS is going to accept your application. They're going to issue biometrics so you can go do your fingerprints, but they are not going to be able to adjudicate, meaning render a decision on your case, because the decision whether to proceed with this new law, Biden's parole in place, or make adjustments or stop is frozen. It is pending litigation. It is pending court litigation. So until we have the final results, the government, USCIS, can keep accepting applications. Now, they issued an order, an administrative stay through September 23rd. We are now at the 18th. September 18th is when I'm giving this live. So the first stay was issued to September 23rd, which is next Monday. So we were telling everyone, hurry up, let's file these applications because the stay is through the 23rd. The Fifth Circuit has weighed in here and they have extended this stay through, I believe it's October 10th is the new date. On that date, they're going to have oral arguments, but they're not going to issue a final decision. They are deciding another piece of this case. They're deciding if other people can join in and be part of the case. So in simple terms, on October 10th, they're going to have another hearing on this case that they're litigating the validity of Biden's parole in place, and they're not going to make a final decision on whether this law that Biden has introduced can move forward or not. They're going to make a decision about other matters in the case. So, what does that mean? As of now, if you qualify or think you qualify for Biden parole in place, you have until October 10th to submit your application as of right now, which is the 18th of September when I'm giving this live. So as soon as you can, get in touch with our office. We do free case evaluations. You can book a paid consultation with me if your case is more complicated, like you have an order of deportation, multiple entries, or a criminal history, and we can discuss. But bottom line is, if you think you qualify for Biden's parole in place, you need to apply right now. You need to apply right now. Even though the October 10th date is down the road, it's actually not too far away. I think it's about 2 or 3 weeks from now. We need time to put your case together, and we need to do it well. We need to do your forms. It's an online filing. We need substantial evidence in your case and to discuss it. And we need time to put everything together and review it multiple times through our paralegals, through our attorneys, and make sure everything is perfect for submission. So if you believe you qualify for Biden parole in place, definitely get in touch with our office as soon as possible. Do not wait. So again, there is an October 10th administrative stay in the Fifth Circuit through October 10th. Because of the nature of that hearing and the matters that the judge will rule on, it is not the meat of the case. My suspicion is that it will go beyond the October 10th date. So it could go on for another 2 or 3 months where they are still staying the decision, meaning USCIS will accept applications, they will process applications, issue biometrics for you to go do your fingerprints, but they cannot give a decision. They cannot give a request for evidence, they cannot give an approval or a denial, or really do anything. So this may go further past October 10th, but as of now, it's October 10th. And not too long ago, it was September 23rd. So the key thing here is this gives people more time to understand if they qualify, more time to have a consultation, more time to gather documents, more time to gather the money to hire the attorney. So this is all good news. And one big takeaway where everyone is asking, well, what happens if this law goes away? Well, a big thing to remember, and we've seen it be true with cases like DACA or DREAMers, Deferred Action for Childhood Arrivals. We've seen it with TPS. If you get your foot in the door, if you are able to get the benefit, which they're accepting applications, it is very difficult for the government then to take away a benefit that they've already given you. So I always give the example of DACA and how people who receive DACA, they get to renew and keep DACA year after year. But for those who are just trying to apply, I don't know, yesterday as an initial DACA applicant, they can file their applications, but because it's in pending litigation, similar to Biden's parole in place, they will not make a decision on the case. So if you get the benefit, it's very hard due to a concept called due process for the government to take that benefit away. So if you want to get in the door, I would do it as soon as possible. Now is the time, and I'm so happy we're doing this live so I can reach you guys and let you know The new due date for this administrative stay is through October 10th. So we need time to get your package and application together to consult with you. So do it as soon as possible. Get with us as soon as possible. All right. So let's see some questions that you guys may have on the live. Okay, so can you discuss who does or does not qualify for adjustment of status pending parole in place? Okay, so basically parole in place is to be able to adjust your status. That is the whole point of the law of parole in place by Biden, to keep families together. The reason is if you've entered undocumented, you have basically committed a civil violation of our immigration laws and you are inadmissible to the United States. So because you entered without documentation, the government is not just gonna wipe that clean. They're gonna require you to leave the United States and come back through the proper channels, which would be consular processing, meaning going to the consulate in your home country, going back to your home country, getting that green card and coming back to the US. And to make it more complicated, when you leave the country and you've been in the United States unlawfully, meaning undocumented, for more than a year, you are then subject to a 10-year bar. So before Biden's parole in place, if you're married to a US citizen, in order to get your green card, you would have to apply for a special waiver, get that waiver approved. The legal standard for that waiver is extreme and unusual hardship to your qualifying relative, which is likely your spouse, maybe even your US citizen children. So you have to win that hardship waiver, which is extreme and unusual hardship, so meaning your spouse is suffering from a disability, a illness, physical illness, financial hardship, something exceptional and extreme. So once you get that approved, which right now is taking several years, it used to be 6 months before COVID, now we're looking at 2 years, maybe even close to 3 years. Get that waiver approved, so when you leave to go consular processing, you already have an approval to waive the 10-year bar. So you're subject to that 10-year bar. You can't re-enter unless you have that approved hardship waiver, and then you re-enter after your consular process. So it's a very lengthy, very expensive process that, unless you have a family suffering from extreme and unusual hardship, it's not an option for you. Then they introduce Biden paroles in place. So that is a way that they are basically saying you don't have to leave the country, you don't have to apply for a special waiver, you won't be subject to the 10-year bar, and you don't have to spend this time and money that could really be 3, 4, 5, 6 years, and go through the risk of leaving the country and having any other issues like a criminal record or gang affiliation where you can't re-enter the country because you're subject to other bars aside from the way that you enter the country. So all of that is to say, it was very complex. It still exists. You can still use it if you don't qualify for Biden's parole program. But essentially, this new program allows for you to apply, be accepted, and then have the ability to have work authorization, apply for your green card while you're in the United States, and not have to leave and re-enter or even prove extreme and unusual hardship. You're really just proving you're married to a US citizen, you've been here for 10 years, and you don't have any criminal record that is barring you from applying. So it's a much simpler, much faster, cost-efficient, cost-saving process for you to be able to get your green card in the United States. So that is kind of the logic behind this. For your question, if who does or does not qualify. Okay, I have applied. Here's another question for an I-130 spouse on green card. I became a citizen and had contacted USCIS, told me 30 days wait. Okay, so not sure what the question is here, but it looks like someone who had a green card applied for their spouse, and then that same person who was the petitioner, green card petitioner, became a citizen. So you want to upgrade your petition by sending USCIS documentation and proof that you are a citizen and no longer a green card holder. That's also going to change the time frame and the category of your case. So I don't know any other details of your case, but this would be a great case for us to look into for you. So I highly suggest that you contact our office so we can look at your receipt notices, look at when you became a US citizen, and figure out what are the next steps for your spouse, and where is your spouse, if they're here or abroad. And then I have a question here. How could I schedule a 30-minute consultation? So if you want to do a free case evaluation for 30 minutes with our intake team, you can look at our links on our social media pages. It's on our bios. You can go to our website, tilimmigration.com, and click book a case evaluation. We are available. We're even available on Saturdays. And last I checked, it's free on Saturday, so go and book it. We have Lily working this Saturday, and she's amazing. She has, I believe, over 11 years of immigration experience. So go ahead and book with us. If you want to have a paid consultation with me, you should do that free case evaluation, and then they can set it up for you. Or you can send us a DM and let us know, hey, I would like the link for your paid consultation. We'll be happy to send it to you. We can even link it when we repost this live, so that you can have access to us. Don't waste any time. If you want to meet with me for a consultation, don't waste any time. We'll get you the link and we can talk. Okay. Can I get advanced parole while 601A is pending? Is it safe to travel to another country, not home country? No, you cannot. Okay, 601A. So this person is talking about a waiver, the hardship waiver, which the form is the 601A. It's one of the forms. Advanced parole is a travel document. So no, you cannot get a travel document with a pending hardship waiver if you have no other status. The normal process for a hardship waiver, as I was discussing, is a family petition, hardship waiver to waive the 10 years bar that you are subject to, leaving the country, consular processing, and coming back. So if you go through that process, you don't need a travel document to go back to your home country or even a third country for the consular processing. You just go back, and we would already have set up your whole consular processing case and get you an interview. So you only go back for that interview. So you don't need a travel document. But if you're not to that consular processing stage and you haven't been approved for a 601A waiver, you cannot travel because you don't have anything underlying. A family petition approval is not a status. It's more of a step to getting to a status. So if you don't have anything else like TPS, DACA, obviously you don't have a pending green card because that's what the 601A process is for. You cannot travel with just the hardship waiver. So that's a big no to that. Will filing bankruptcy help me bring my husband or affect me bringing my husband to the US? So if you're filing for your spouse who is abroad and you're a US citizen, a green card holder, and you file for bankruptcy, yes, it will affect your case, because one thing you have to prove to the government is that your intending immigrant, so your spouse who's going to immigrate to the United States, is not a public charge. That they're not going to come to the U.S. and need assistance from the U.S. government. U.S. government is not like that. Trump administration hated that. They made so many new rules and forms that we had to fill out to prove the person's potential, the immigrant's potential to come to the U.S. and speak the language, work, and be able to be financially independent. So part of the regular process is showing that you can financially sponsor the attending immigrant. And if you can't, we can help you get a co-sponsor, find out if they qualify in place of you because you have filed for bankruptcy and you cannot show the income sufficient. Now, bankruptcy is very complicated, so without knowing more about your case, I can't tell you if we can proceed with you or if we need a co-sponsor, but I'm just highlighting that this is a requirement that the petitioner, green card holder, or U.S. citizen can financially sponsor all their dependents, plus anyone they've ever petitioned for until they become a U.S. citizen, plus the intending immigrant. Okay, so it could be a number of people. All right, I want to go overseas and get a fiancé visa for my wife. Well, you don't have to go overseas to get a fiancé visa for your wife. You can give us a call and we can get it done for you. It doesn't require you to go anywhere, like to an interview or anything, but it does require for you to be a U.S. citizen. So U.S. citizens can petition for their fiancés. We love fiancé visas. We love to help people with those case types. So definitely give us a call if you're interested in doing the fiancé visa if you are a U.S. citizen. You also cannot have any kind of criminal record that has to do with domestic violence. So if you're a U.S. citizen, you want to file for fiancé visa, make sure you don't have a criminal record like assault and battery against a household member in Virginia. That will be a big problem for you. If you have another type of criminal history, we can always discuss and see what the options are. But you don't have to go overseas. Obviously, if you want to go overseas to see your fiance, you can and visit them. You should have visited them at least in person once in the last 2 years. This also says for my wife. So they cannot be your wife for a fiance visa. They have to be your fiance. That means you gave them an engagement ring, promise ring. You have the intention to get married once they get their fiance visa and come to the United States, and then you guys get married. If it's your wife, we're looking at a spousal petition, spousal green card petition. Okay, if you came in on a visa but then got married, can you stay in the U.S.? What forms do I need? Well, it's a lot more than forms, so you should give us a call. It depends if you married a U.S. citizen. Did you marry a green card holder? What kind of visa did you enter in? Some visas are bars of adjustment of status to getting your green card. And also some visas have other requirements like physical presence requirements. So without more information, I cannot tell you. And again, it's not just forms, it's evidence, government filing fees, photos, all of this stuff the government requires you to put it together in a very specific way. That's why we're here to help you. So definitely give us a call, and we love doing these case types for spouses, so we can definitely help you with that. Okay, next question. Is parole in place on indefinite pause? No, it is not on indefinite pause. I explained that earlier in this live, and I'll explain it again. So there is an administrative stay. So it is on pause, but it's not indefinite. Right now, they're having a court hearing on October 10th. They're going to be deciding other matters like who can enter the case, like the Immigrant Coalition, and it's likely that they are not going to make a final decision. So they may extend the stay. Now, what is the stay? The stay is USCIS is accepting Biden's parole in place applications. They are issuing biometrics or fingerprint notices, but they cannot adjudicate. They cannot make a decision. They cannot grant. They cannot grant it. They cannot deny it. They cannot issue a request for evidence. So now is the time to put in your application if you qualify, because if they do take it away, then you won't be able to apply at all. So it's better to get in than miss out. But it is not indefinite. There is specific timelines. We require time to put your applications together, so sooner you can talk to us, the better. Okay. Someone said, my probation ended in 2021 for DUIs. When can I apply for N400? So for N400s, meaning citizenship or naturalization applications, you must prove good moral character. So part of good moral character is you cannot be on a active sentence with, a criminal court could not have ordered you for an active sentence, a suspended sentence, or probation, supervised or unsupervised. A lot of people don't understand that unsupervised probation. It can be, we are giving you 3 years in jail with 2.5 suspended for a period of 5 years if you keep the peace and good behavior. That period of 5 years of keep the peace and good behavior is unsupervised probation. Every USCIS local field office is different, but I can tell you in Virginia, they have let's say internal policy, you cannot demonstrate good moral character for your naturalization application if you are on any kind of restrictions by a criminal court, including supervised and unsupervised probation, okay? Again, give us a call. We can look at your criminal record. We can tell you when you can apply, the specific date. We can also potentially start working with you until we get to that date, and then what other documents you would need to kind of outweigh your criminal record and show that you're a person of good moral character and you have rehabilitated yourself. Okay, someone said that they're waiting for biometrics. Is that on pause too for parole in place? It is not on pause. We are getting biometrics. It is a very specific process for fingerprinting. So if you don't have an attorney and you want to consult with an attorney, I think you should really go through this process with an attorney. We contact our clients and explain and set up the biometrics process for them. But no, it's not on pause. Can you help filing H4 application? How can I make an appointment with you? You can visit our website. You can go to our social media pages and click and make an appointment with us. You can also send a DM, a direct message, if you want my consultation link. All right, let's see. Who do we have here? Okay. Is it possible to get a green card if the other spouse lives in another state due to work? It's possible, definitely something to discuss with an attorney, some strategies about documentation, how you're gonna discuss this at your interview. Will it raise some flags with USCIS? Definitely. So there are things that we can do and say and prepare you so that you can still obtain your green card. All right. Can you help me with my brother's case? I applied in 2015 in Afghanistan. His case is in NV, says no visa. I'm not sure what you mean, but we work with Afghan cases. I speak Farsi, and other people at our office do as well. So we'd be happy to help you. You can book a consultation. My dad is blind. Can he get accommodation to the citizenship test? Yes, he can. Usually if you get an accommodation for naturalization, they want to know if you can read American Braille. So if your father is blind, they're going to want to know, can he read American Braille? That would be the accommodation that they can provide. Is he legally blind, or is there, things that he still can read if they are big print? So they're going to ask some of those questions. So when you fill it out, that helps them figure out how they can make the accommodation for you. But yes, absolutely. Okay. All right, so these are awesome questions. I see some questions about OPT and EB3 as well as military parole in place. So we are out of time, guys. Thank you so much for joining. I can't see everyone on TikTok because my camera is flipped, but I know TikTok is always amazing and you guys are super supportive. I see some of you guys on Facebook. Thank you so much for joining. Last thing I want to say, a lot of questions on how to book a case evaluation. Guys, it's in our social media bio. So if you're on Facebook, go to our bio. If you are on TikTok, go to our bio right now. You can click and book a free case evaluation with our team. You can also go to our website, tilimmigration.com, and click. It's right on the front page. Book a free case evaluation. If you want to meet with me and do a paid consultation, I promise you we will make a post with that link. We'll make a post with that link after this live shuts down. And you can also send us a direct message that you would like to meet with me for a paid consultation. And we will put a portion of that paid consultation towards your case if you sign up with us. And the last plug I want to make is Biden parole in place. If you are married to a U.S. citizen, have entered undocumented, do not have a criminal record, and has been in the United States for at least 10 years, you probably qualify for Biden's parole in place. It is on an administrative stay, so this is your potentially last chance to get your application in and get fingerprinted and move forward with your lives. So give us a call. October 10th is the new administrative stay date in which the Fifth Circuit is going to hear this case. Could it be much longer? Yes, it could be. It could be another 2 to 3 months, but we never know. And we have upcoming elections early November, which is like less than 2 months from now. So please, guys, if you qualify for parole in place, give us a call. Give us an opportunity to work on your case before this deadline. We don't know what's going to happen, but I'll absolutely keep updating you. Follow our newsletter for all the updated information, as well as follow and like us on social media. And we're on TikTok, Facebook, Instagram. Visit our website. Those are all places where you can book case evaluations with us. Another big announcement, guys, we opened our DC office. Super exciting, and we're really catering to people that qualify for employment-based cases, people that are doing investor visas, E2 investor visas, opening businesses in the United States, people that are of extraordinary ability, people that have a very long and prestigious resume in whatever their field is, whether it's art, video production, or it's STEM, science, technology, engineering, mathematics. So whether you're in the STEM field or the art world and you're of extraordinary ability, even athletics, we are working with those individuals. So we know that DC has a ton of universities, international organizations like the World Bank. So if you know of anyone, or you yourself are in the DC area and you believe that you qualify for an employment-based type case, definitely give us a call. Feel free to schedule a paid consultation with me directly. We would love to work with you here in our nation's capital. Thank you guys so much for joining this live. Again, I'm Solmaz Sigavi. Thanks, guys. Great to see everyone.